The next case is the School District of Orange County versus the Orange County Classroom Teachers Association. Let everybody get situated real quick. How much time would you like for rebuttal?
5 minutes, Your Honor.
Okay, you may begin.
May it please the Court, good morning, Your Honor. John Pomeraney, Associate General Counsel, Orange County School Board. This case centers around a contract dispute between the Orange County School Board and the Orange County Classroom Teachers Association. Let's be clear, I want to be clear. There is no right under Chapter 447, the Public Employee Relations Act, for the Classroom Teachers Association to utilize our email system, send communications either to members, dues-paying members of the union, or non-union members.
Now, that was part of the CBA.
That is completely part of the collective bargaining agreement. It is not part of the law. In fact, PERC has held that an employer has the absolute right to prevent a union from utilizing its email system. So this was completely a contract dispute.
Well, when you say contract dispute, are you contesting there was an issue on interpretation, or was the issue solely as to whether there was a violation or not?
I believe the issue was whether or not there was a violation of the contract by the district. Clearly, it says, the contract says that they are allowed to send emails to employees under our contract. Employees would mean members and non-members. Their allegation was that we didn't allow them to send emails to non-members on one or two occasions that they actually pleaded. So,
well, their allegations were more than that. I mean, their allegations were that your representative told their representatives on more than one occasion, you are not allowed to do this. That's a lot different than one or two violations.
I would dispute that from the standpoint of what they alleged in the charge.
On that?
There was evidence on that. However, they didn't plead that in the charge. I believe you're referring to the statement from Mr. Howitt to Mr. Melamed that PERC relied upon, which said that we're not allowing you to utilize our email system to send emails to non-members. First, that was never pleaded in PERC cases, which I have cited to this court, say we don't care if it was argued in court, argued before the hearing officer. We don't care if it was decided by the hearing officer. If it wasn't pleaded, we don't decide it. So PERC...
Well, their allegation was that there was an intentional decision on your part not to comply with this contract, and they list two examples, but to show evidence that it's intentional as opposed to accidental, they put on evidence that your individual said you're not allowed to do this. I mean, that you don't need to plead that. That's evidence confirming the intentional part of the allegation, right?
It's evidence that goes to whether or not the dispute was whether or not the violation was intentional. I would agree with that. However, the question is, well, how can this be remedied? And our position has always been this is a purely contractual right. This could have been remedied in an arbitration hearing, and we asked for PERC to remedy this in an arbitration hearing because there was no implication of public policy under Chapter 447. This was always a dispute about whether or not we violated a contract. Trust me, I deal with their grievances every day. I deal with them in arbitrations every day where they allege you have violated the contract here and on various provisions of it, and it always is a grievance process and an arbitration process. And an arbitrator in this case could have ordered us, just like PERC did, they could have ordered us to allow them to utilize the email system.
Let me ask you this. Is it a discretionary decision on whether to defer a matter like this to arbitration? That calls for yes or no. Is it a discretionary decision?
It's discretionary, yes.
Standard review is abuse of discretion.
Yes.
All right. Are you aware of any cases where a court has determined that PERC abused its discretion by not referring a matter to arbitration?
As I sit here today, no, but the cases that I've reviewed are cases where parties have asked for it later in the proceeding. And they have, the cases where PERC has refused to order a case to arbitration are cases where the courts have said, or PERC has said, listen, not only is this a contract violation, but it violates some sort of policy as enunciated in the Public Employee Relations Act. If you look at what the commission ordered in its final order, it says that we are to cease and desist from interfering with the employee's contractual right to receive communications through the Orange County School District email system. Again, they're not saying that what we did violated any independent statute of Chapter 447. What they're saying is you violated your contract. And for us, it is an abuse of discretion. The Manatee County School Board case that they cited, and the factors that PERC looks at when they decide whether or not to remand a case to arbitration, does the allegation in the charge center on a labor contract violation rather than upon a question of law under Chapter 447? PERC itself is admitting that this is purely a contract violation, not a 447 violation.
They had specifically alleged, not a couple of individual instances, but that as a matter of policy, the school board took the position that that they were not entitled to use email? Is it your position, if it had been that kind of an allegation, it would be an abuse of discretion not to send it to arbitration?
That assumes that that's what, I'll answer your question, but I want to clarify that that's not actually what they alleged in this case.
Your position is they only alleged a couple of individual.
Right.
But if they had alleged it as a general policy, is it your position that still, since it's a matter of contract and not statute, it would be an abuse of discretion not to send that kind of claim to arbitration?
Yes, Your Honor, because once again, it is purely a contractual right. PERC is held in multiple cases, which I've cited to this court, they have no right to utilize our email system. The only thing that gave them the right to utilize our email system is the contract. I would think public policy, as enunciated in Chapter 447.401, is that we want disputes under contracts. It says there shall be a grievance procedure to decide disputes under contracts which culminates in final and binding disposition by a neutral arbiter of the question. They had a remedy under the contract, they had a remedy under the law to go have our alleged violations of the email provision in the contract to be remedied.
But is that an exclusive remedy? What authority is there that the arbitration is the exclusive remedy for that situation?
They could not, I believe the authority is Chapter 447.401, the statute that says we will have an arbitration provision. We are mandated to have a grievance arbitration provision in our contract, and we are mandated to decide all questions which arise under that contract under that grievance arbitration provision in Chapter 447. So if it's not other than one or two instances which they pled, unless it's a wholesale repudiation, we're never going to let you do it under any circumstances. Our position is they have to go through the grievance arbitration machinery first.
I said in response to my hypothetical that even if it was an allegation of a wholesale repudiation because it arose under the contract and not the statute, they'd still have to go to arbitration.
I'm sorry, and I misspoke, Your Honor. That is my position, that they have to go through the grievance and arbitration machinery first. 447 and PERC is there to remedy actual violations of Chapter 447, not the contract between the parties. Quite frankly, they said in the City of Miami Supreme Court case when they talked about whether or not PERC has the right to defer this to arbitration, we've set up 447.401 so we can have these disputes decided without resort to state intervention. The Supreme Court has recognized that, and PERC has held previously. I don't know why PERC has deviated from its previous precedents. They say when a dispute centers around a provision of the contract, it says arbitration is favored when the issues involve interpretation of a collective bargaining agreement.
So is there a difference between arbitration is favored and arbitration is required?
I believe favored in that instance and how they were using it is, we don't want to be involved in these disputes if you can solve them in arbitration. So I believe favored, it doesn't say required, and I will acknowledge that, but it's favored. It's what PERC has said we want you all to do. We don't want to be involved in your disputes under your collective bargaining agreement. You already have a process in place to decide those issues. So utilize that process. So we favor you going to arbitration to solve contractual disputes. Now, even to the extent that you believe that it shouldn't be deferred and that PERC had the right to solve this, I want to point out a couple things. Number one, a repudiation of a contract is a violation of 447.5011C. That is a failure to bargain in good faith, or is that's a refusal to bargain. As I pointed out in my materials, the union never pled a 447.5011C violation. They only pleaded a 447.5011A violation, which is interference, restraint, and coercion of the public employee's rights under Chapter 447. Their position is, since they pleaded a 1A violation, that necessarily encompasses a 1C violation. It actually doesn't. The case law says from PERC, and as approved by the courts, when you plead a 1B violation, or in this case a 1C violation, it's a derivative of a 1A violation. It's a derivative 1A violation, but the converse is not true. No court's ever held that the converse is true.
So if a repudiation of the contract is a statutory violation, what's the basis of your contention in this case that even, in my hypothetical, even if they had alleged a repudiation, they would had to have gone to arbitration?
The basis of the argument is there's a repudiation provision in 1C, which basically, it's a PERC-developed case law interpretation of 1C. They've said a refusal to bargain or a failure to bargain in good faith. They've interpreted that to include concepts such as a repudiation of a collective bargaining agreement provision. But you can't look at that in isolation. There's also the Chapter 447-401 arbitration provision where they say, we've set this up to decide contract disputes that arise solely under a contract. This is not... The cases that I've seen involving repudiation involve things, let me step back for a second. The cases I've seen that involve repudiation involve questions where it's not just a violation of a contract provision. That contract also has, that contract violation has also independently violated another right contained in Chapter 447. I believe one of the cases says, well, there was a dispute over a reopener provision, and there was a contractual reopener provision, but that reopener also encompassed the right to have bargaining done in good faith and to actually have bargaining with the union. No other contractual right under Chapter 440, or no other statutory right, under Chapter 447 has been implicated by this. PERC has even acknowledged it. The only right that's been implicated by this is a contractual right. So if the only right that's been implicated is contractual, by 447-401 it has to go to arbitration. But they didn't plead repudiation and they didn't plead a 1C violation. So PERC has said, if you don't plead a violation under Chapter 447-1C, we won't consider it. Once again, even if it's argued, even if it's alleged, or even if it's argued in the hearing, and even if the hearing officer decides it, they don't decide issues that aren't pleaded. So, and they can't rely upon the derivative cases that say a 1C violation is a derivative 1A violation. It doesn't work the other way. But going again to, even if you believe that repudiation was properly before the commission, they haven't proven repudiation. Repudiation requires, and this is a basic, collective bargaining agreements are interpreted just like regular contracts. And I've pointed out cases in my materials that say they have to tender performance of conditions precedent before they can state a repudiation claim. Now, let's look at the evidence that was presented. The contract requires that before they send an email over our system, they have to give it to the superintendent or her designee 1 business day before it's sent out. They proved on one occasion, the November 5th email about Election Day, that they sent an email actually to us that we refused to allow to go out to non-union members.
You had told them, we're never going to let you use our email system to send anything out they would still have to submit each email to you for prior approval for you to turn it down, for them to have a claim? Or could they use that as in essence, an anticipatory breach such that they don't have to then give you the email because you've already told them you're not going to send it out?
No, Your Honor, I believe they have to present the email to us every time. Until that happens, it hasn't, in my opinion, become ripe for
Even
for
if you have
determination.
already told them you're not going to send any email out?
Well, I want to look at the evidence. I
Why
don't,
isn't that you said this is covered like any other contract law. Why wouldn't it be an anticipatory breach which frees them from the obligation of their conditions precedent because you've already told them you're not going to live up to the contract?
I don't think the evidence in this case I think the evidence demonstrated that they were talking about a spring 2013 conversation with Mr. Melamed. I believe that's what you're referring to.
I'm talking about my hypothetical now, because you said in my hypothetical, if you had told them we're never going to send one out, they would still have to submit each one to you before they would have a claim. And my question to you is, based on my hypothetical, why wouldn't that be an anticipatory breach which would release them from arguments about conditions preceding?
Because they still have to show some ability to perform. They would have had to say, we were willing to say we were going to produce these emails to you before they can state anticipatory repudiation, in my opinion. There has to be some tender of performance. I believe even under anticipatory repudiation,
I don't think that's the law. I mean, to give you an example, I mean, if you're going to deliver 100 widgets to someone, they're going to pay you $10,000, and a week before that, your delivery date, they call you and say, we're not going to pay you whether you bring the stuff here or not. You're basically making the argument that you'd still have to drive the widgets up to their doorstep, knock on the door, and only then could you sue. And that's not my understanding of the law on anticipatory repudiation.
this, of course,
Anticipatory breach of the contract.
Right. But once again, it goes to the facts that it was what actually was proven here.
But your argument to this court was that they had to tender regardless of whether there was an anticipatory breach by your client. And that's, I think, the problem that I'm having with your argument. If you want to argue the facts here, that's different. But to say that they had to prove a tender in each case, notwithstanding any finding that your client told them you cannot use our email system for non-members. I mean, if you want to argue the facts, that's fine. I'm having trouble with your generalization of the law.
And I apologize for that. I don't mean to cause the court confusion.
I don't think it's an accurate statement of the law is what I'm saying.
I understand, Your Honor. I just believe under the contract that we have, they were required to tender that performance. Mr. Melamed's statement that he said he had the conversations with Mr. Howard, I believe he testified, was spring 2013. This November 5th, 2012 Election Day email, that was the one email that they tendered.
But if Mr. Howard had sent an email a couple months before these instances and said, look, I don't care what the collective bargaining agreement says, you cannot use our email to send information to non-members, would it still be your position that they would have to prove that they tendered emails?
I'm sorry, and now I understand the court's question better. In that scenario, no, Your Honor, I believe. If he had said outright, I don't care what the CBA says, you're not going to be able to utilize
How about if he didn't say, I don't care what the CBS said? How about if he just says, you're not going to be able to use our system?
I don't know that, I don't think that's a distinction with a difference. I think if he says you're not going to use the CBA or the email system, or I don't care what the CBA says, you're not going to utilize the email system, I don't.
Did the hearing officer basically find that that's what Mr. Howard did?
He did it he said Mr. Melamed told him that, Mr. Melamed testified he told him that in, I believe, the spring of 2013.
And the hearing officer, right or wrong, accepted Mr. Melamed's testimony over Mr. Howard's testimony?
I believe that's correct, yes,
You
Your
only
Honor.
have a minute left. Do you want to save it, or you want to, you have a minute,
I will save, it
Your
for
minute
what.
for rebuttal, okay.
Thank you.
If it please the court, I'm Toby Love. I'm representing the Orange County Classroom Teachers Association. We think that PERC properly applied the law and not deferring the case to arbitration. There are two cases on it, City of Miami and Indian River School Board, and both of them state that it's a matter of discretion for PERC, and it's the rare case that gets deferred. And it's not granted where there's a possibility that the claims implicate statutory and policy concerns.
Mr. Lev, let me jump ahead and ask you about one of the sanctions, because you did not address, one of the sanctions that was imposed by PERC that was raised on appeal, but you did not address in your answer brief, and that is the posting requirement.
Okay. Yeah, I recognize that when I read the reply brief, and I sent another supplemental authority. I don't know if the court received it or not.
But you know, you made the argument below that to require your clients to post at every place was expensive and an unnecessary expense. Now, why wouldn't that same rationale apply to their argument that it's an unnecessary expense for them to be required to post the results of this case?
I'm not following the question. The union made the argument below that posting was a necessary expense?
No, they made the argument.
Oh,
They made the
okay.
argument below that you had alternative ways to communicate with non-members, and one of the ways they said is you could put stuff on bulletin boards.
Oh,
And your response has been that that's an unnecessary expense and cumbersome, et cetera, and plus not every school has a bulletin board, and not everyone sees the bulletin board, et cetera. Okay, now they've argued on this appeal that the sanction of posting is an unnecessary expense. And I'm kind of seeing it that way too, and maybe you can convince me why it's not.
I wish I thought of this argument earlier. I wasn't anticipating the connection. First of all, we had a contractual right to use the email system.
I'm just talking about the sanction.
All right. First of all, it's not an expense for them. They can email the document to 180 schools in a few seconds, and they can post it on the bulletin boards. And it takes no more effort than anything else they have to post on the bulletin boards. It's not a question for them of being 10 miles away in a union office and having to find 30 people to drive around the Orange County school system to 180 different locations and personally post the emails. Here, they can order somebody who's on their staff, who's a paid employee, to post those documents. And the document is very important. It's designed to remedy a statutory violation. We've been fighting about this. The employees deserve to know what the outcome of the case is. This has been a standard remedy.
You don't think your client's going to tell them?
Not as effectively. It's supposed to be posted in the schools. One of the problems is we get into these kind of battles, and does our client have credibility when they say this is what happened, this is the result? It's been deemed more effective for over 80 years, beginning with the National Labor Relations Board, to have these documents posted. And it's not like we're putting them in stocks and publicly humiliating them. I think that's an overreaction. It's just a piece of business. This like got litigated. It ended in a particular way. The employees deserve to find out. And it's a deterrent to future violations. That if they have to acknowledge they violated the law, it reinforces the notion that the law is above them and not below them, and it deters them violating again. And it's not like we're flagellating them. For 40 years, PERC has ordered the posting of notices, except in very unusual cases, one of which was over 30 years ago, and it came out of this court, which I think was an anomalous case. But it's the exception to the rule that it's not regarded as a significant expense. It's a small expense. They're constantly posting things on their bulletin boards or sending out messages on their email, and this is just a part of doing business, and not to do it, to keep the results of this case obscure, would turn on its head about a practice that's existed for 30 to 40 years. The only exceptions I'm aware of are the very close cases where PERC would not award attorney's fees because there was no blatant violation, the law was kind of gray, the employer had a good faith intent, and under those circumstances, then it would be excessively punitive if somebody did the best they could with gray law that was ambiguous and erred in the view of a court. In this case, where they determined that the employer knew or should have known what it was doing, in that case, it's very appropriate to post a notice. Are you convinced?
You've answered my question, thank you.
Okay. Moving on to the other issues, on deferral, I guess that's been hammered. If you look at the ULP charge, it did allege a constant refusal, and it said then, for instance, on this date and this date, but alleged a continuing refusal, and it also alleged a violation of the duty of fair representation. It's kind of unheard of that an employer could grant union access to a bulletin board or email and then make it only send emails to members and not non-members. There's a duty of fair representation. Union has to represent everybody. The school board can't give the union a bulletin board and then prohibit non-union members from looking at the bulletin board. So this to us was a violation of the duty of fair representation and also a repudiation of the contract, not a one or two time breach of the contract, but an ongoing repudiation of it. That being the case, we alleged things that implicated violations of statute, violations of the Constitution, violations of policy. When that occurs, it's inappropriate to defer to arbitration, as stated in Indian River School Board, for instance. This is not just a breach of a contract, but a refusal to honor a contract that got negotiated, which is an incident of bargaining in bad faith. And PERC relied upon that Indian River School Board case with good reason. There, an arbitrator tried to delve into issues about bargaining in bad faith, and the appellate court said that matter was preempted by PERC, that the arbitrator had no jurisdiction to delve into whether they violated 447 or not. I want to talk a little bit about the anticipatory breach and the violation of a condition precedent, and I agree with everything the court said about anticipatory breaches. But I do want to add that even if there was some duty of going to them every time and saying, here it is, do you approve it, the union complied with that duty. There's a provision in the contract that said the document had to be provided 24 hours in advance to the school district for them to look it over, and the union complied with that provision and gave the documents 24 hours in advance. What the district seems to be arguing is they got to give it 24 hours in advance twice, once for the union members, and then like ask for some special permission a second time so it can go out to the non-union members. And of course, the contract never said that, and the contract never differentiated between union and non-union members. So this idea of having to comply with the condition precedent twice is not in the contract, and it's been invented, as well as what the court recognizes an anticipatory breach in this case. I want to address briefly this A versus C violation. The cases say that conduct such as this is an A and a C violation, and I want to remind the court that the district, on their pre-hearing statement, which contains the issues to be tried, said the issue in this case is whether they repudiated the contract or merely violated it once or twice. And in their proposed recommended order, they asked the hearing officer to find that they didn't repudiate the contract, they just violated it once or twice. So So they're trying to seize on a legal technicality, and I think they're incorrect in their interpreting the law, but they've argued the case. They were on notice of what the issue was, and
Well, what he argued was that if you plead an A violation, that doesn't mean that you're pleading a C violation. But if you plead a C violation, because it's a derivative of an A violation, then you, in essence, have pled an A violation.
Well, I understand
So
about the...
Can you answer that?
Yeah, the same, there are times when the same conduct that constitutes a C violation also constitutes an A violation. In this case, the manner in which the contract was repudiated not only was bargaining in bad faith, which is a C violation, but also interfered, restrained, and coerced the employees in their right to collectively bargain, which was an A violation.
Right, but he's saying you didn't plead a C violation, and because you didn't plead a C violation, that shouldn't be considered. We should only consider
Well,
an
they
A
didn't
violation.
consider a C violation. The only violation they relied on was the A violation, except the A violation embraced the same conduct, and repudiation of a contract is both an A violation and a C violation. And that was our position. I think that's PERC's position. I think I've hit everything, unless there are further questions from the court.
Question? No? All right, thank you. Got a minute left.
Very briefly, Your Honors, I just wanted to get to, they talked about a violation of duty of fair representation. I believe the evidence is undisputed that one was never claimed by a non-member, one was never alleged by a non-member. That to us is a red herring, number one. Number two, they had other contractual obligations, as Your Honor pointed, or contractual avenues, as Your Honor pointed out, the bulletin board, they had the courier system, they had employee mailboxes at all of our schools in order to communicate with non-members, and admittedly by the union president, they didn't utilize those contractual avenues. So they didn't violate their duty of fair representation to communicate with employees. They just didn't utilize all of the avenues they didn't utilize all the avenues that were available to them. And the Gator Lodge case, which I cited in my material, says if we turned them down to utilize our email system, they still had other opportunities to communicate with non-members. So there was no unfair labor practice violation. Thank you, Your Honor. We appreciate the consideration.
Okay, we're going to have a panel change now.